The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of July 5, 2026, the podcast that finds 100 ways. This is your host, Shane Killian, and it's a special edition of the podcast because we have a
Supreme Court special. It's another Supreme Court special. Every single story. Were they right? Were they wrong? Man, are they just dumb? Find out in the Supreme Court special.
Yes! We're doing our third Supreme Court special. Our first was in July 2013, the next in July 2018. Now here it is, July 2026, and it's time for number 3. Every single story in this edition will be about one of the recent Supreme Court decisions, for better or for worse. And of course, it'll be no holds barred as we go over what they got right and what they got wrong, as well as who they triggered. So strap yourselves in, prepare for the fun, and remember to keep your head and arms inside the podcast until it has come to a complete stop. Let's start with the Monsanto decision, and Maha did not like this one. Yes, it's about glyphosate, known under the brand name Roundup. For so many years in the podcast and on my YouTube channel, I've covered the misinformation about glyphosate and the myth that it causes cancer. IARC, a branch of the WHO who insists that every single substance in the universe causes cancer, literally, has been the basis for numerous ambulance chasers going after the deep pockets of Monsanto. In particular, John Darnell claimed that 20 years of using Roundup caused his non-Hodgkin's lymphoma. He claimed Monsanto should have had a warning label, a Missouri jury agreed, and awarded him over $1 million. The Supreme Court just said that kind of lawsuit is invalid because warning label requirements are federal jurisdiction, not state. Darnell's evidence was shaky, bordering on laughable. Cherry-picked lab rat studies, correlations full of confirmation bias, IARC, and then, of course, nothing else could be shown to have caused it, so it must have been Roundup. Meanwhile, more reliable health authorities, including others in the WHO, as well as the EPA, the European Food Safety Authority, and the European Chemicals Agency, have all found that normal levels of glyphosate exposure is not likely to cause cancer. But he didn't have to actually prove it to win his case. He just had to show that there was enough of a question that there should have been a written disclosure on the product. If you've ever wondered why there are 27 different warning labels on a frickin' stepladder, it's because of crap like this. But just as the lower court didn't rule that glyphosate causes cancer, the Supreme Court didn't rule that it doesn't. This is a case about how much authority states actually have, and Kavanaugh, writing for the majority, said that the Federal Insecticide, Fungicide, and Rodenticide Act requires such labels to go through the FDA. In fact, it would have been illegal for Monsanto to comply with the lower court ruling. Quote,
subject to narrow exceptions not relevant here, the manufacturer may not change the label unless EPA subsequently approves a manufacturer's proposed change or EPA itself requires a change to the label. If a manufacturer does not use the EPA-approved label, it may be subject to civil and criminal penalties.
By the way, all rulings are given in text. These are AI recreations just to make it a bit more interesting. As for the evidence, quote,
in 1991, EPA classified glyphosate as unlikely to cause cancer in humans. In 1993, EPA reiterated that conclusion and re-registered glyphosate products without a cancer warning. After the International Agency for Research on Cancer classified glyphosate as a probable carcinogen, EPA re-examined the issue but still adhered to its long-standing position on glyphosate. In 2020, in an interim registration review decision, EPA reiterated that same position. Therefore, as a matter of federal law, Monsanto legally must use a label without a cancer warning unless and until EPA approves or requires a change.
They didn't rule that Monsanto can't be sued or that glyphosate is safe now and forever. Jackson and Gorsuch dissented, and I have no clue what has to go wrong for those two to agree. Jackson's long and predictably dumb dissent made contradictory claims, such as the lawsuit didn't create new labeling rules, and it said they shouldn't sell products with inadequate warnings. But how does she think you warn people about problems with products if not the label? She also claimed that it leaves injured people without a remedy, which it doesn't. It just means that if you make a failure to warn claim, it has to be in federal court. All right, on with the Maha triggering. U.S. Right to Know President Gary Ruskin said, quote, "This ruling is a giant gift to a foreign chemical company and an insult to American farmers and workers whose cancers arose from the use of the herbicide Roundup. In essence, it puts the chemical industry above the law and will have far-ranging effects that make Americans more likely to get sick from toxic exposures." John Davidson of Friends of the Earth, that name tells you everything you need to know about them, doesn't it, said, quote, "We're profoundly disappointed that the Supreme Court has restricted farmers' and consumers' ability to hold pesticide manufacturers accountable for the harm their toxic products have caused. Now, Congress has a moral responsibility to put people's health over pesticide industry profits by codifying a legal pathway for those hurt by toxic pesticide exposure." Hey, fun fact. Organic pesticides have far greater toxicity levels than Roundup. Just saying. Maha podcaster Alex Clark said, quote, "The Trump administration urged and pleaded the court to reach this result to protect a foreign chemical company, and it did at the expense of Americans. What happened to America first? For an administration that promised to take on corporate capture and make America healthy again, this is a stunning betrayal. Farmers, families, and cancer patients currently in litigation with Bayer will never forget this." And Vani Hari, the food babe, posted to X, "I am literally sick. This is a devastating blow to every family that trusted our justice system. This is a defining moment. Every elected official now has a choice. Stand with families harmed by toxic chemicals or stand with the corporations that profit from them." You remember our coverage of her. She's the one who didn't realize that our atmosphere is 78% nitrogen when she complained about airlines pumping it into planes at 35,000 feet. In other words, air circulation. Why are people still listening to her? All right, enough of this one. Glyphosate doesn't cause cancer. That's complete pseudoscience. But more relevant to this is what's called alarm fatigue. Did you actually read all 27 warning labels on that stepladder? Would you have been more likely to read it if there had only been 2? When was the last time you saw people actually react to a car alarm? With anything other than a wince, I mean. When the signal-to-noise ratio is that low, your brain, quite correctly, starts discounting a stimulus that has a low prediction value. The fix isn't to make people more vigilant, which doesn't work because willpower isn't the bottleneck. The fix is to get rid of all of the noise so the actual warnings don't have to compete for attention. If you ask me, this should only be the first step to stopping this trend of everyone warning against every little thing because of fear of being sued. And now, from the Captain Obvious department, people born here are citizens. We covered the oral arguments in Trump v. Barbara, the birthright citizenship case, back in April. In fact, we spent over 15 minutes covering them, so we won't rehash them. Listen to the April 5 podcast if you need to catch yourself up. All caught up? Yeah, pretty bloody obvious, isn't it? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. How do you misinterpret that? Well, if you're Clarence Thomas, you take 91 pages to do it. He based his entire dissent on the idea that this was a response to the Dred Scott decision, so therefore it only applies to freed slaves, despite describing a more general principle. Again, the disputed phrase is subject to the jurisdiction thereof, but if you listen to our April 5 edition, you already know the issues with that. The Supreme Court already decided this back in Wong Kim Ark, but Thomas says that's only because the parents were domiciled here, even though the 14th Amendment doesn't use that word and Wong Kim Ark doesn't rely on that concept. The majority ruling blasted him pretty much point by point. We have more than a century of precedent. We have the ratification debates. We have, then and now, the very narrow exceptions, such as children of diplomats, and basically showed that Thomas's dissent was inconsistent with the amendment's text, history, and long-standing precedent. But one thing Thomas's dissent is extremely well written. That's acknowledged even by scholars who take the opposing view. Now, it should be said that both the amendment and the decision say that Congress can alter this with legislation, but they haven't. In fact, Congress has granted birthright citizenship by statute. And since this is about a presidential executive order, he doesn't have the authority to go against Congress. Well, just as the Monsanto decision triggered Maha and the environmentalists, this one triggered the right. Mike Davis exed. 5 justices betrayed us in the most egregious manner by stealing our most crucial sovereign power and responsibility, controlling who becomes one of us. These 5 justices put their vanity over our sovereignty, security, and country. This is unforgivable. Daniel Turner, president of Power of the Future, said, quote, "The constant diluting of our citizenship. Everyone can vote. Everyone's a citizen. Everyone gets Medicaid. Everyone qualifies for food stamps." Senator Eric Schmidt said, quote, "The Supreme Court's birthright citizenship decision is wrong, dangerous, and disastrous for American sovereignty and the American people. The Supreme Court's decision constitutionalizing unlimited birthright citizenship for the children of illegal aliens and temporarily present aliens is wrong and disastrous for our sovereignty and the future of our republic." White House advisor Stephen Miller said it was, quote, "one of the most destructive and outrageous decisions in the long history of the Supreme Court. American citizenship is not the birthright of the world. It belongs only and solely to Americans. No provision of the Constitution can be read to require our national self-obliteration. It's the end of America as we know it." And I feel fine, because the fact is, birthright citizenship has been the rule since the country's founding. The worst Supreme Court rulings have been the ones that followed a wave of political trends instead of just going with what the Constitution says. This one thankfully avoided that.
Presenting the greatest game this side of Yugoth. You are H.P. Lovecraft's cat, and your name is Nick. Right, we can't say that on a podcast. Well, anyway, that's the point. Your name is a joke, so now you are out for revenge. You become the Necronomicat. Using the Necronomicon, you come to the present day to buy a cat. That's a gun. For a cat. It's a fat cat. But the Necronomicon is treacherous, and it let in Lovecraft's monsters. Now, in a crumbling world, you must fight. Build your team, buy guns and armor, buy items of dubious legality, defeat the bosses of each level, then take Lovecraft down. Play Necronomicat. The link is at cat.bogosity.tv. Yeah, we're doing cat.bogosity.tv, not that other one. What, you want me to get kicked off the internet or something?
Alright, let's do a simpler one. The unanimous ruling in U.S. v. Hamani, which says that you shouldn't be denied your right to keep and bear arms just because you smoked a doobie that one time in college. Gorsuch wrote the opinion, quote,
The law automatically bans an individual from possessing a gun from the moment he becomes an unlawful user of any controlled substance until he ceases being one. The law says the government doesn't require anything more. It doesn't matter what controlled substance an individual uses, in what amounts he does so, or whether his drug use has ever made him a danger to himself or others. It doesn't even matter why he keeps a gun or how safely he does so. And for violating this automatic ban, the government insists an individual like Mr. Hemani may be sent to prison for up to 15 years and disarmed for life. We appreciate that drugs and guns can sometimes make for a dangerous mix. We appreciate, too, that the government's effort to analogize a modern statute addressing drug use to historical laws must be approached with a sensitivity to the fact that many drugs well known today were unknown in early America.
Yeah, except for all the ones that were, including, maybe even especially, marijuana, an important cash crop for many colonial farmers. He concluded,
The government invites us to draw an analogy between its present regulation and historical laws addressing habitual drunkards. But the government's analogy fails under every measure it asks us to consider. The historical laws on which it relies targeted different kinds of people, did so for different reasons, and operated in different ways. And faced with all these shortcomings in the government's submission, we cannot say it has carried its conceded burden of showing its prosecution of Mr. Hemani complies with the Second Amendment.
You can't just say they rocked the ganj or did smack and therefore they can't own a gun. They have to show that this person fits into a historically recognized category of dangerous individuals. It's not everything we need by a long shot, but it's a big step. Oh, look, you can't ban free speech just because more than one person's doing it. Remember the firestorm the Supremes caused when they ruled that way in Citizens United? Well, now they just rule that way with regards to political parties as well. This one was 6-3, the 3 liberals dissenting. Once again, we see who hates free speech. Judge Kavanaugh wrote for the majority,
The First Amendment's protection of free speech has its fullest and most urgent application precisely to the conduct of campaigns for political office. With respect to campaign-related spending, the central holding in Buckley v. Vallejo is that spending money on one's own speech must be permitted. For that reason, this court has determined that political parties, as well as candidates, private individuals, and outside groups, may make unlimited independent expenditures during political campaigns. But the modern congressional limits on political party-coordinated expenditures restrict that coordination and the party's speech. The limits impair the party's traditional forms of communication, such as advertisements, preclude parties from amplifying the voice of their adherents, impose additional monetary costs and burdens on political parties, and inflict a stifling effect on the ability of the party to do what it exists to do. In short, constitutional text, history, and precedent establish that the political party coordinated expenditure limits violate the First Amendment. Importantly, by holding FICA's political party coordinated expenditure restrictions unconstitutional, the court's decision today treats all political parties equally. Whether the Democratic Party, the Republican Party, or other parties, all political parties and candidates going forward can compete equally under the same rules regarding coordinated expenditures and can structure their fundraising, spending, and political speech on a level playing field as they see fit within the law.
And the only opposition, of course, was whining about corruption. But the fact that some people might be corrupt isn't an excuse to take away everyone's right to freedom of speech. And anything that levels the playing field between parties has got to be better than whatever additional corruption creeps into the system. Overall, this enables third parties and independents to oppose that corruption. Another small but welcome step. Boys will be boys and girls will be girls, and according to the Supreme Court, that's the way it shall be on our nation's sports fields. They found that Title IX actually protects women from biological males who want to compete with them. No one fully dissented, although the 3 liberals filed opinions dissenting in part, but concurring with the judgment. Kavanaugh wrote for the majority,
Title IX transformed American sports and American life, enacted in 1972. That landmark law promoted equal opportunity for female student athletes and has facilitated the extraordinary growth of women's and girls' sports over the past 54 years. To ensure equal opportunity for female athletes, schools therefore typically maintain separate women's and men's sports teams. Women's teams compete against other women's teams, and men's teams compete against other men's teams. In recent years, some biological males who identify as female have sought to play on women's or girls' sports teams. That modern development has triggered national and international concerns about safety and competitive fairness for female athletes, as well as related worries about preserving equal opportunity for women and girls to play sports. The question is whether Title IX permits schools to maintain women's and girls' sports for biological females. The answer is yes. The dissent directs various rhetoric against the court's opinion, employing phrases such as contorted logic and misguided approach and diminished view of equal protection and unencumbered by fact or law. With respect, that rhetoric is misdirected. The court's holding today is straightforward. The Equal Protection Clause allows schools to maintain separate teams for female and male athletes. Schools may determine eligibility for women's and girls' teams based on biological sex. That policy is constitutionally justified by the vitally important interests in safety and competitive fairness, so as to provide equal opportunities for women and girls to participate in sports. And when a sex-based classification is justified as a constitutional matter, as it is here, states need not make case-by-case exceptions. We do not accept the dissent's assumed monopoly on understanding the effects on individuals involved in disputes over transgender athletes. We are acutely aware of the difficulties sometimes faced by boys who identify as girls and by girls who identify as boys in middle school, high school, and beyond. But in conducting the equal protection inquiry, we must also account for the effects on girls who are forced to compete against biological males in sports.
Should have been a no-brainer.
I'm brother Ezekiel, and I know how naughty thou hast been. So naughty, thou needst a VPN. Hide thy iniquity from prying eyes, and make sure the liturgical authorities remain ignorant. Take thy browser to vpn.bogosity.tv to get BoxPN. At $6.36 a month, a price only the most penurious would balk at, thou shalt have unlimited high-speed connections to servers all over the globe. And they don't log connections. Thy privacy is assured. That should please you sinners. Just remember, the Lord sees all. When traveling, make it look like thou art still home. At home, ensure the elders at your ISP don't take out their judgment with traffic shaping and DMCA notices. Up to 5 devices can connect at once, almost one for every deadly sin. Keep thy sins private. Go to vpn.bogosity.tv.
And now it's time to cross-examine this week's biggest Bogon emitter. I mean, you know it's gonna be. Who else could it be in our
Supreme Court Special?
The Fifth Amendment says in part, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The question has always revolved around what just compensation actually means. In the intervening centuries, we have evolved quite an understanding about what counts as a taking, what is property, and what is public use. But just compensation has always been slipperier. If government seizes land, they're supposed to give the owner the fair value of the land as payment in money. Courts and lawmakers since then have thrown out terms like inherent value and market value. But the Supreme Court's opinion in Pung v. Isabella County just took a hard left turn. A family owed more than $2,000 in property taxes, so authorities in Isabella County, Michigan seized the house and auctioned it off. They had assessed the home's value at $194,400 for tax purposes, but sold the home at a public auction for just $76,000. No attempt to list the property to get a proper offer of sale was ever made. They just did a lowball auction and gave the family the remaining $73,000 and change. It didn't help that they never got the notice of the tax bill and no other proceedings were held before the seizure and auction. And the Supreme Court upheld that, saying, quote,
the proper baseline for measuring just compensation following a tax sale is the auction sale price, not the property's hypothetical fair market value.
And it was unanimous. They basically set up different rules for tax disclosures than eminent domain. And that differing rule meant that the family only had to get 39% of the value that very same tax authority had been using to levy those taxes in the first place. There's a glaring omission here. Alito repeatedly uses the term fairly conducted without defining it or explaining what it means. I guess as long as the auction isn't rigged? They present their opinion as an originalist interpretation, but originalist scholars had assumed that the court would decide the opposite. The founding era concept of just compensation was about making the owner whole, and a depressed sale doesn't do that. In fact, in 2023, they decided Tyler v. Hennepin County, where they said that a county can't keep the value of a home exceeding the unpaid tax debt. But as Thomas says in his concurrence,
the county argues that the history of tax foreclosure sales supports its conduct here. I agree that sufficient historical evidence can justify an exception to the fair market value rule, and I join the court's opinion on that basis. But any exception based on history can be no broader than what that history justifies. And on my initial view, any history of tax foreclosure sales reflects a greater respect for principles of just compensation than the county showed the pungs here.
So the county can just show up on your door, say they're taking your house, not let you contest it, sell it for a pittance, and give you crumbs, and that's A-OK with the Supreme Court. Not even any attempt to list the home through a realtor and get the best price. In fact, these tax auctions are pretty much guaranteed to give you a lower price because, unlike a listing, buyers can't inspect the property or get financing, the sale is often as is, and there's not even that much of a public notice. I mean, when was the last time you just happened to hear of an auction sale of a home in your county? They don't exactly market these things. They just put them on display at the bottom of a locked filing cabinet, etc., etc. Not to mention the fact that these homes are often bought by realtors or other investors to turn around and flip them for a much higher price. They buy that home for $80,000 and then turn around and sell it for $200K. They make a cool $120,000 and the homeowner is left with none of it. In fact, I wouldn't be at all surprised if there was some sort of backroom dealing about that sort of thing. It seems like they've only approved auctions because we've always done it this way. But that was based on a completely different housing market than what exists today. Basically, you no longer own your homes. The tax authority can come and take it, and even if you don't end up owing anything, you'll still only get a pittance of your value back. Why would any sane person agree with that? So all of that makes the Supreme Court this week's biggest Bogon emitter. And now it's time to give out 2026's second Silver Cluon Award. Of course, it's going to be the Supreme Court because it's our
Supreme Court Special.
But that doesn't mean they're not deserving of it, because as bad as they were on the Fifth Amendment, they did a really good job with the Fourth in Chaudhry v. United States. Okay, so dude robbed a bank. Like, who does that these days? And police collected all the cell phone location data in the area to locate the perp. They applied to Google to hand over the data on every cell phone within a 150-meter radius of the credit union, including all customers, employees, and bystanders in a 3-block radius. So Google dutifully handed over everyone's private location data, including that of Akello Chaudhry, who just wandered into the geofence and left immediately towards a residential area. Before 2018, our cell phone data wasn't protected. Then, the Supreme Court ruled in Carpenter v. United States that cell site location data is protected and needs a warrant to access under the Fourth Amendment. So Chaudhry fought to have the geofence evidence suppressed. But although the lower court found that the warrant violated the Fourth Amendment, they allowed it anyway under the good faith exception. Basically, officers can behave as horribly as they want as long as they believed in their hearts it was valid. On appeal, an en banc Fourth Circuit panel tied 7-7. Now, the Supreme Court majority found that it was a violation of the Fourth Amendment. Alito, Thomas, and Barrett dissented. Sorry, no Cluons for them. Justice Kagan wrote for the majority,
The government is wrong about the incapacity of short-term location information to reveal private matters. Repeated patterns, in the government's phrasing, are not all that individuals wish to, and reasonably expect to, keep to themselves. Return here to another of Jones's insights. Even short-term monitoring of a person's physical movements can provide a wealth of detail about his familial, political, professional, religious, and sexual associations.
We've shown that in the past. On the 7 September 2015 podcast, we show how people were able to use Australian reporter Will Lockendon's metadata to conclude all sorts of things about his life, and also come to some false conclusions as well. Kagan wrote,
Still more fundamentally, we have never understood Fourth Amendment protections as kicking in only once an intrusion goes too far. Where the Fourth Amendment applies, it applies regardless of the quality or quantity of information the government obtains. So, for example, this court held that thermal imaging qualified as a search, even though it did not, and was not likely to, detect private activities or intimate details.
And it was only that narrow because Google insisted on it. They wanted to hand over as little information as possible. Had it been up to law enforcement, they would have gotten a lot more.
For all those reasons, we hold that police officers invade a cell phone user's reasonable expectation of privacy when they access his location history. It does not matter if the time period scrutinized was only 2 hours, nor does it matter that the materials obtained were handed over by a third-party tech company. When the government accesses historical cell phone location information, location history as much as CSLI, it conducts a search under the Fourth Amendment.
They didn't throw it out entirely. It's up to the Court of Appeals to decide whether that search was reasonable and supported by probable cause. But now they have to actually make that assessment. Law enforcement doesn't get a free pass. Let's take a quick look at Alito's dissent, though.
8 years ago, I warned that this court's decision in Carpenter v. United States would produce one of two outcomes. Either the court would need to clarify Carpenter's limits in a future decision, or Carpenter would usher in revolutionary developments in our doctrine by giving criminal suspects a protected Fourth Amendment interest in any sensitive personal information about them that is collected and owned by third parties.
You say that like it's a bad thing. Well, I don't want to dwell on the bad. This is a good decision, and 6/9 of the Supreme Court deserve this shiny new silver Cluon. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now let's subperpondentestational arbitrationify this week's
Idiot Extraordinaire.
The Constitution makes it clear. The President is the entirety of the executive branch. That's Article 2, Section 1, Clause 1. The executive power shall be vested in a President of the United States of America. Period. Full stop. End of statement. So here's a big question. Can the President fire whomever he chooses? Well, the Supreme Court has said clearly and unmistakably that he can. And the Supreme Court has said clearly and unmistakably that he can't. Wait, what? In Trump v. Slaughter, they ruled that the President can remove FTC commissioners at will, but apparently not so Federal Reserve Board members as per Trump v. Cook. And if you're wondering how the court changed in between those two decisions, well, they were both released on the same day. Yes, they're both part of our
Supreme Court Special.
In Slaughter, the Supremes overturned Humphrey's executor, finding that the removal provision is contrary to the separation of powers. Writing for the majority, the 3 liberals dissented. Roberts pointed out that Humphrey stylized the FTC as, quote, quasi-legislative and quasi-judicial functions. The problem is, the FTC is clearly the executive branch, which means the president's in charge. Quote,
the Constitution vests the executive power in a President of the United States of America and instructs that he take care that the laws be faithfully executed. To vest the whole executive power in just one person was not to suggest that he could execute the laws alone and unaided, but it was to establish a hierarchy, a chief magistrate with whom the buck stops, and below him various assistants or deputies who derive their offices from his appointment and remain subject to his superintendence. To remain accountable to the president, those officers must be removable by the president.
He then goes into a good history of how that came about and points out that Myers in 1926 established that the president had the power not only to appoint postmasters, but also to remove them. Humphreys, on the other hand, was, quote,
tethered to a highly circumscribed and almost fictional view of the FTC's role. Humphreys, by its terms applied only to agencies that occupy no place in the executive department, are independent of executive authority and exercise no part of the executive power. Indeed, Justice Sutherland took pains to emphasize that the character of the office, executive or non-executive, would determine the result of future cases, and to reiterate that the court's decision was limited to officers of the kind here under consideration. Soon enough, we recognize that Humphreys flunked even its own test. It is hard to dispute that the powers of the FTC, even at the time of Humphreys' executor, would at the present time be considered executive, at least to some degree. Not one for understatement, Justice Scalia observed in dissent that the court had swept Humphreys into the dustbin of repudiated constitutional principles. The court put the matter more delicately, but no less definitively. We undoubtedly did rely on the terms quasi-legislative and quasi-judicial in Humphreys, the court noted, but our present considered view is that the constitutional question cannot be made to turn on such rigid categories, at least for inferior officers. If anything more is left of Humphreys, we overrule it.
Wow, no mistaking there. We know how they'll rule in every such case from then on, right? Okay, yeah, Trump v. Cook. In which we forget about all of that and stop Trump from removing members of the Federal Reserve Board. Thomas, Alito, Gorsuch, and Barrett were the dissenting voices on this one. God damn it, Roberts! And what's the difference? Well, they don't say. Roberts was the one who flipped, and Roberts wrote the opinion in both cases, and it's like 2 different judges. Roberts claimed that the Fed's independence and insulation from accountability is rooted in our nation's history and tradition, even though the Federal Reserve itself isn't rooted in our nation's history and tradition. Basically, at-will removal is the default rule for executive officers, except for the Fed because reasons. So much so that you can't even get over the minimal requirements just to get a stay. The only reason given is, get this, property rights. Lisa Cook said, and the appeals court agreed, that public officials have property rights in their position. Therefore, firing her was a taking under the Fifth Amendment. I mean, what? But Slaughter says that Congress cannot constitutionally limit the president's removal authority. So that means that the statutory for-cause protection never created a valid entitlement in the first place. And if there was no valid entitlement, there is no protected property interest. Hey, Kavanaugh, you concurred. Can you clarify?
We should not leave open the question whether the Federal Reserve can remain an independent agency in the wake of Slaughter. After Slaughter, there is a clear choice. Either the Federal Reserve may remain independent with the governors removable for cause, not at will, or it may not. Leaving that question open would create significant uncertainty about whether the court might soon eliminate the Federal Reserve's independence and thereby expose the Federal Reserve to political influences and jeopardize the efficacy of U.S. monetary policy. Even temporary uncertainty about the status of the Federal Reserve could spark political upheaval, including confusion about whether the president could immediately remove multiple governors at will, as well as turmoil in the U.S. and world economies. I would not go down that road. would not risk destabilizing the U.S. economy just so that we can further mull over an issue that, in various permutations, we have been thinking about for many years.
Wow. Okay, so much for you then. Thomas's dissent is right on.
Today, this court denies the president a stay of that injunction, allowing Cook to continue to exercise executive power after being removed by the president. The court's decision is incorrect. Cook's office was not her property because in this country, government officials do not own the public offices in which they serve.
The fact that this even has to be said in writing shows how far we've fallen. And remembering our earlier coverage of Pung, this means that government officials have more property rights than we do.
Apparent mortgage fraud was a cause to remove Cook, and the statute authorizing the president to remove Cook for cause says nothing about notice or a hearing, so it does not require notice and a hearing. Any other result would violate Article 2 of the Constitution, under which the president may remove executive officers at will. The court makes many policy arguments for an independent banking agency that exercises executive power free from accountability, but those are ultimately arguments against the Constitution. This court has held that a plaintiff cannot obtain relief against anyone, let alone the sovereign, without a right of action, but now it rules that Cook may obtain such relief without identifying one. It has held that federal courts lack equitable authority to interfere with the removal of public officers, but it recognizes an exception to that rule for Cook. And it has held that Congress and the judiciary cannot encroach on the president's exclusive and preclusive powers, which include his power to remove executive officers, but it prevents the president from exercising that power here. Although the court expresses concern that the president removed a board member for the first time in the Federal Reserve's 111-year history, it expresses no such concern, that it today upholds an injunction against the president's removal of an executive officer for the first time in the Constitution's 237-year history. I respectfully dissent.
Mic drop. Well, not really. He went on to attack it for another 31 pages. But now, not only can the president not remove Fed members, but we've got one who's a known fraudster we can't get rid of. Wonderful. So all of that makes the Supreme Court this week's Idiot Extraordinaire. Well, that wraps up this
Supreme Court Special
edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord, Patreon, or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Learned Hand. I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes. Believe me, these are false hopes. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.